Let me seek your Lordship's indulgence. My Lord, with regards to item number 1 of part 2, my Lord.
You are interested to do the matter today?
My Lord, I've received a copy of the follow-up action taken by the additional SP. If your Lordship will allow me to produce a copy of the same, my Lord.
Let the matter reach what is. Do you have any prayer today?
Because I have not made this by way of an affidavit.
You would like to place it by way of an affidavit?
Yes, my Lord. If your Lordship will allow me to file it by way of an affidavit.
Yoshba, and one more, Yoshba, if they may kindly give a time frame by which the investigation will be complete, they may be directed to, because the investigation is being going on.
Let this be placed on record. We'll consider your prayer. Okay. You are the State Council.
Yes, my Lord.
So Responsible London State Council submits that the status report.
Yes, my Lord.
Status report has
Follow-up status report.
Follow-up status report has been received by him, which he would like to place on record by way of an affidavit. Full stop. As prayed for. Time, a week's time is granted. 2 weeks' time is granted to file such affidavit. Para? List immediately after the winter vacation.
Obliged, my Lord.
May I seek your Lordship indulgence in making a mention of part 2, item number 2, my Lord?
Yes.
My Lord, the matter is fixed for hearing today. I have some personal difficulty in conducting a hearing this week, my Lord. If this matter can be listed after vacation, my Lord.
Here for whom?
The state appellants, my Lord.
Okay. The respondents have been informed?
Yes, my Lord. I have taken the consent.
Okay. On the prayer made on behalf of the appellant, matter is adjourned to be listed after the winter vacation. Yes.
I'm deeply obliged.
May I seek your Lordship's indulgence on mentioning?
Just a minute. On a request made by the Learned Government Council through online, only. Yes.
Lordship, regarding item number 8 of part 2 hearing list.
Yes.
As my senior is out of station, having a hearing matter on the principal bench, my Lord, if the matter may be fixed after vacation.
Yeah, for the appellant.
Yes, my Lord.
Oh, it's an old matter. Routine matter. Okay. Considering this is the last week before the winter vacation, otherwise 13 matter, no further adjournment.
It's pending
Yes,
for
Okay.
quite long time. You know?
Yes. More than a decade has passed.
Yes.
Okay. A prayer for adjournment has been made on behalf of the appellant. Para? Considering that the appellant citing personal grounds of the Learned Council. Para? Considering that the appeal is of the year 2013, this court has reluctantly adjourned the matter to be listed immediately after the winter vacation.
And my Lord, if similar order may be granted for item number 9 and 10. Wherefore the respondents.
9 and 10.
Yes, my Lord.
Again, all matters. 9 and 10. For the respondents. No, part 2. Part 2.
Yes, my Lord, part 2 item 9.
Part 2, 9 and 10, respondents. And instead of 2013, one will be 2016, one will be 2014. This is the same matter with matters of 2014/16. 8 is over of 2013. This is 9 and 10 and connected. Okay, instead of 13, it will be 14/16. One order. Okay. Immediately after the winter vacation.
Yes, my Lord. And my Lord, regarding item number 15, the appellant is intending to engage another outstation counsel, so if the matter may be taken up after winter vacation.
Okay. Yes, inform the state after the vacation. Item number 15. The Learned Council for the appellant has informed that a senior counsel will be engaged, for which he seeks time. Para? List after the winter vacation.
Much
Item
obliged, my
15 is.
Daily list for motion, item number 1.
Lordship, this item number 1 is analogous, similar case with item number 8. In item number 8, last week, this Honorable Court directed the Government Council to go through the matter and whether it is a covered case or not.
Okay. Or that land compensation?
Yes,
Okay.
the same, this similar matter.
Yes, my lord, this matter is regarding the cess deducted by the state.
10%.
10% cess.
Okay, yes.
Yes, my lord, I contact the concerned department whom I have represent. I am representing the defendant number 5 and 6, my lord.
Okay, okay.
6 and 7.
Okay.
And as per my instruction, my lord, this matter is concerned with the respondent number 1, 2, and 3.
Okay.
So, in
Who-
this regard,
Who
I
is 1, 2,
cannot-
and 3? Anybody appearing for 1, 2, and 3?
They
Not
have
yet,
no
my lord.
standing council, district council, Mara Autonomous District Council.
Okay.
They have no standing council.
Then we have to issue notice, I think.
Yes, my lord.
Okay. We'll make a returnable date. Let them appear, and if we have their views, and if they say that it's covered, then we'll dispose of these matters. Okay? Item number 1 and 8 as well.
8, yeah, you can club together, Your Lordship.
My lord, regarding this item number 8, this is not a similar matters.
Is it?
Regarding this item number 8, the appellant had claimed for the interest matter.
Yeah, that is the judgment covered, the previous judgment.
So-
That is,
Regarding with item number 1, the appellant had claimed only for the cess amount.
Yeah.
And the covered case which they had
however, Your
mentioned,
Lordship, the judgment, the previous judgment covered interest as well as
Yes.
Yeah.
Okay.
and my lord, what I would like to mention regarding to item number 8 is that in that prayer portion, I think there is a clerical mistake. In the prayer portion that is.
Let's do one thing. Let's first issue notice in item number 1.
Yes, my lord.
Then we'll take it separately. Okay? Let the matter reach. Heard Mr. and Learned Counsel for the petitioners by which, a prayer has been made for refund of the 10% deduction from the land acquisition compensation in the form of cess. Full stop. The Learned Counsel submits that the matter is covered by an order passed by this court in WPC 60/2023. Full stop para. Let notice be issued, returnable by 6 weeks. You are the CGC.
No, my lord. I'm for the state government.
Then who will be appearing?
My lord, I'm for respondent number 4.
Who's for 1? Competent authority, Kala. Who's for Kala? Anyone for Kala? Okay, then who will be, 2 also steps should have to be taken, Mara Autonomous Council.
Yeah, we have to.
Senior revenue officer, I think will be
Yes.
taking. Ms. Swinson, Learned State Council accepts notice on behalf of respondent 3. 3, madam, anyone else? And 7? 3, 6 and 7.
6 and 7.
3, 6 and
State
7. 3,
government.
6 and 7. Union of India,
For respondent number 4, my lord.
Ms. Swinson, Learned CGC, respond number 4. National Highway, Sri Swinson, Learned Standing Council, respond number 5. Extra copies within 2 days. Steps for service of notice upon the respond numbers 1 and 2
Yes.
shall be taken by registered post with AD. Steps within 2 days.
Even 3, Your Lordship.
Huh?
1, 2, and 3.
Why? Who is 3?
3 is senior revenue official.
Senior
Under
revenue-
MSD.
Oh, okay, Mara. Okay. 1, 2, and 3. 1, 2, and 3. And state council is only for 6 and 7.
Yes, my lord.
6 and 7, not 3. Okay.
Item number 2.
Item number 2. You have filed the IA
Yes, the Lordship, we have filed the IA
for implement.
for implement of the
Ministry.
ministry
Okay.
represented by the Secretary to Government of India, Minister of Health and Family Welfare,
Okay, first we pass order in the implement application.
the Lordship.
Okay. Heard Sri Swenso Learned Senior Counsel for the applicant assisted by Sri Swenso, who by means of this application has prayed for implement of
The Secretary
the
To the Government of
Secretary,
India.
Government of India, Swenso, parasitically pastry, as response number 3, full stop. In this regard, the Learned Senior Counsel has referred to the order passed by this court on
on the,
6/12/2024 in the connected writ petition.
yes,
Full stop. Para, considering that the impugned decision also involves the aforesaid ministry, comma, the instant application is allowed. Full stop. Consequently, the Swenso is implemented as response number 3. I stands disposed of. The before disposal, the Sri Swenso Learned Counsel assisting the Senior Counsel is accordingly required to file amended past title incorporating the response number 3.
yes, we'll do that.
Okay, in the main writ petition, heard Sri Swenso Learned Senior Counsel for the petitioner assisted by Sri Swenso, full stop. By the instant petition, the petitioner has expressed his grievance with regard to holding him ineligible for the post of professor,
Yes. But in bracket pharmacy,
in bracket pharmacy in the Regional Institute of Paramedical and Nursing Sciences, Aizawl. It is submitted that the rejection has been done erroneously by holding him ineligible. Let notice be issued, returnable on, we fix the date, returnable on 17th of January. 17th of January, after the reopening, first week itself.
All right.
17th of January.
Lordship, we have an interim prayer.
Yes, 3. You'll accept for
Respondent number 1 and 2, my lord.
1 and 2.
Yes, my lord. On behalf of my senior.
Okay. Sri Swenso Learned Counsel representing. And who appears on instruction of Sri Swenso, Standing Counsel, accepts notice on behalf of respondents 1 and 2. Michael, please give the names, okay?
And Lordship, CGC may represent.
CGC, madam?
Item 2.
Ms. Swenso Learned CGC, accept notice on behalf of the newly implemented response number 3. That extra copies of the writ petition be served on the Learned Counsel for the respondents. Para. Sri Swenso Learned Senior Counsel prays for an interim order. Full stop. It is submitted that the petitioner has the adequate length of service and meets the eligibility criteria. Full stop. On the other hand, comma, the Learned Counsel for the respondents has submitted that the rejection has been done on objective criteria, which was also reviewed by the ministry. Full stop. Para. Considering the aforesaid and balancing the equities, comma, it is observed, and this court is of the opinion that while there would be no blanket stay of the recruitment process as it pertains to appointment in an important post, comma, all actions taken pursuant to the recruitment process would be subject to the outcome of this writ petition. Full stop.
Lordship.
This court also makes it clear that any appointments made shall be done with a condition that it would depend on the outcome of the writ petition.
Obliged.
Otherwise, third party right may accrue tomorrow. It will be in difficulty. Okay.
Item number 3.
My lord, if I may, a copy of this writ petition may be furnished.
Yes, we have already said while notice, issue notice. And file the this amended application. Okay, amended cost title. Yes. Next.
Good morning, my lord.
Item
My
number
lord,
3. Yes.
item number 3 to 7, Lordship. Lordship, I
yes.
humbly apologize for not being physically present due to certain
Doesn't matter.
exigencies and
What is
urgency.
this?
Lordship.
What is this?
Lordship, I'm appearing for Power Grid Corporation of India Limited.
Yes.
Lordship, as per my charter of duties, we are engaged in the transmission of electricity,
Okay.
and for that we need to set up electrical systems.
Correct.
Lordship, in that certain transmission systems were being set up in the state of Mizoram to provide electricity to the state. Now, Lordship, these are all high tension transmission systems. Lordship, straight away, if we could come to page number 138. As because, Lordship, during the ongoing construction, there were several landowners who were affected, and accordingly, as per section 10 of the Telegraph Act, especially 10B and 10D, which we have been empowered under 164 of the Electricity Act.
Correct.
Lordship, we had, being the competent authority, we had adduced the quantum of compensation and paid the same. Lordship, being aggrieved with the same, these landowners, they approached the competent court, that is the district judge,
16.4.
under 60, district judge, Lordship,
16.4.
for enhancement of, Lordship, 16.3, 4 and 5.
16.3. Okay.
Lordship. Now, Lordship, when they approached the court under 16.3, the court in the judgment, Lordship, page 138.
Yes.
If I may, Lordship, the court itself, it says that this is the case is for non-payment of full compensation, and thus the matter proceeded. Now, Lordship, at page 143, para 3, Lordship.
143.
143, Lordship.
Yes, please.
This is the judgment, impugned judgment.
Yes.
Para 3, if I may, Lordship.
Just a minute, please.
Lordship.
143, para 3. If any dispute. No, there is para 3.
Lordship, the further subsection 5, Lordship.
Yes.
If I may, Lordship,
Yes,
the
yes.
court says,
Please.
further, subsection 5 of section 16 of the said act, provided that every determination of a dispute by a district judge under subsection 3 of section 16 of the said act shall be final. Hence, the grievances of the petitioners with regard to the sufficiency of compensations payable to them can be determined by this honorable court. The
Yes.
court itself says that it is only me who can decide this.
Yes.
And it is correct. It's the correct position.
Yes.
Now, Lordship, when this judgment goes on to decide the matter, at page number, Lordship, 156,
156.
Lordship,
Yes.
grave travesty of miscarriage of justice has happened here,
Page-
Lordship,
page-
para 34.
34. Yes.
Page 156,
Yes.
para 34,
Yes.
Lordship.
Further.
If I may, Lordship, this is the operative part of this judgment.
Please read.
Further, the Deputy Commissioner Kolasep / Collector is to decide the land value upon P Patta. It shall not exceed the land value fixed by the Kala Kolasep on dated 10/1/23 for NH 306 4-lane land compensation. And if any amount of compensation is entitled by the applicants, the Deputy Commissioner Kolasep Collector shall make assessment and therein communicate to the respondent Power Grid for payment. The respondent shall deposit to the Deputy Commissioner Kolasep Collector within a period of 3 months from the date of receiving the said assessment amount, which thereafter shall be disbursed to the applicants. Lordship, the court below has gone to act like a RITCO. It has the duty which was cast upon the court by the legislation, Lordship, section 16(3), the learned court below has delegated that power to the Deputy Commissioner to assess the amount of land compensation. And in line with, Lordship, the Kala proceedings, that is the proceedings which were taken for land acquisition. Now, Lordship, is I am not governed by the Land Acquisition Act. In fact, Lordship, the 2013 Act, Right to Fair Compensation Act, Schedule 4, Entry 13 of Section 105 makes it very clear that I am exempted from any land acquisition proceedings.
This order was passed after adducing of evidence.
No, Lordship. That is the irony in it, Lordship. The judgment, this is the conclusion of the judgment. The court says, let the Deputy Commissioner fixate the compensation. The court did not adduce evidence on the quantum of compensation that was to be
This
fixed.
application was filed with what grievance? What was the grievance?
Lordship, they said that the petitioners had gone to the court saying that the compensation paid is less. They wanted an enhancement of it. Now, under Section 16(3), Lordship.
Okay, what is
If I may read
what is your grievance now?
Lordship, my primary grievance is that the judgment is not sustainable, Lordship. In so much so that the court who was directed, the court who is expected by law to decide on the quantum has not done so and has delegated it down, Lordship. Lordship, Lordship, to sustain this, I am relying upon two judgments. If I may place them before your Lordship.
Yes.
Lordship, the first judgment is passed by the Maharashtra Bombay High Court.
On what point?
Lordship, that the determination has to be done by the district judge and only the district judge.
That is the
It cannot be.
that is the statutory requirement.
It is the statutory requirement, Lordship, and even the Century Textiles matter, the Honorable Supreme Court has at para 37 again reiterated that only district judge can do it.
Okay.
Lordship, now consequent to this, the Deputy Commissioner has done the assessment and execution proceedings have been initiated.
When was the order of the district judge, impugned order?
Lordship, it was passed on 4/10/23, Lordship.
Why were you so late?
Lordship, we have come under 227. However, Lordship, there was a change of counsel and there was
No, why are you
miscommunication
so
which
late?
was happening between
How do you explain the conduct if you think that the entire exercise by the learned judge is not with jurisdiction? And in the meantime, many things
Lordship.
have progressed. Why are you so late? You should have come
Lordship.
immediately.
Lordship, we agree, Lordship. There has been a change of the council, Lordship. There was some miscommunication with the previous council, and the communication letter is also there. We have not annexed over here, Lordship, on the premise of professional conduct. However, if Lordship wishes to peruse, we'll produce it, Lordship. But Lordship, be as it may, on the face there is patent illegality in the judgment, Lordship, and it cannot be allowed to go on any further than where it has come to.
And see, 227 are structured as CRP. So if it is CRP, you have to meet the
Lordship.
requirement of limitation.
Lordship, if I would have come under 115, I agree with what Lordship is saying.
You have
Lordship,
not filed
under
this-
115,
you have not invoked a writ jurisdiction per se. This is not 226, this is 227, superintendent's power.
Lordship,
So it is
superintendent's power.
akin to a revision petition. So you need to overcome the limitation of a revision petition. Simply.
Agreed, Lordship. However, Lordship, under the 115 and 227 will stand different, Lordship, because under 227 the court is empowered to take up a matter on its own wisdom also, Lordship, if something is brought before the court. Lordship, be as it may, Lordship, the judgments have traveled with great privacy. And
Heard Sri N. Khera, learned counsel for the petitioner who has appeared online, full stop, by the instant petition presented under Article 227 of the Constitution of India, the judgment dated 4/10/2023, passed by the learned additional district judge so-and-so in civil application of so-and-so, has been put to challenge. Para. It has been submitted that the application before the learned judge was filed under the provisions of the Telegraph Act, whereby the respondents were aggrieved by the adequacy of the compensation pertaining to transmission of line by the petitioner. The principal grievance of the petitioner, which has been urged by the Learned Council, pertains to the delegation of the exercise by the collector instead of deciding the matter by the learned judge, which is provided under the Indian Telegraph Act. Full stop. Para. It is also submitted. Para. Let notice be issued, returnable by 6 weeks. Deputy Commissioner, somebody is there? Yes, State Council. State Council. Mr. Insular, State Council, accept notice on behalf of respondent number 10. Let extra copy of the writ petition be served upon her by tomorrow. Let steps be taken for service of notice upon the respondent numbers 1, TO2, 9 by registered post with AD. Steps by tomorrow. Para. The Learned Council prays for an interim order. Full stop. He submits that apart from the impugned direction being without jurisdiction and in violation of the provisions of Section 16 of the Indian Telegraph Act 1885, the execution proceeding has also been initiated after an assessment was done by the collector. Para. Let notice be issued on the. This court has, however, noticed that there is a substantial delay in approaching this court. Full stop. Para. Let notice be issued on the interim prayer. Full stop. Returnable by 6 weeks. Till the returnable date, comma, till the returnable date to balance the equities, the further proceedings in the execution case number so-and-so shall remain suspended. Para. Since this order has been passed ex parte, comma, the respondents may come up for modification, vacation, if so advised. Full stop. This court would consider extension of the ex parte interim order afresh on the next date. Okay.
Lordship, similar for item 567, originating on the same principle.
Okay. Numbers are changed. Okay. Give the numbers.
Lordship.
Okay.
And Lordship, also 4, originating on the same principle. 3, 4, 5, 6, 7.
3, 4, 5, 6.
However, Lordship, only in number 4, item 4, the execution proceedings have not been initiated in so much so that we have learned they have initiated, but we have not been served an official copy, formal copy. But 3, 5, 6, 7, the execution proceedings are ongoing, Lordship.
Formal execution proceedings, if any.
Lordship.
Okay.
Highly obliged, Lordship.
Item number 8.
Lordship, the Government Council misunderstanding the prayer portion. It said the as to why the respondent should not be deducted 10%. That she thinks that should be not. It's a negative sentence. As to why.
We should notice that.
Yes. Yes.
Heard Mr. Learned Council for the petitioners who are aggrieved by same thing.
Same thing, Your Lordship.
Deduction
1,
of
2, and
10%.
3. No, here.
10% deduction.
Yeah, you have a MADC is 5, 6.
No. The issue is the same.
Yes, the
Then
issue
same.
is only the cess. Here is not included interest, only cess.
Same one. And Madam, who would be accepting notice?
Here, I'll just check
Same.
it. Just mix up. I'll check it out, Your Lordship.
You should not have too many cases. One case on one day.
It's not. Yes.
Union of India, CDC.
Yes, my lord.
1, 2,
1 and 2, my lord.
1 and 2. Huh? CDC. Yes, CDC 1 and 2. Then
State is three
say
and
you
four.
are
3 and 4.
3 and 4. Madam, state 3 and 4.
Five
5, 6, 5 and 6 by reset post-TD. Oops. In this only cess is there, cess 10% deduction of cess. Okay.
For admission, item number 9.
This was left out in the first one. This was it, huh?
Sorry. Your Worship, this matter may kindly come up after the vacation, Your Worship. Pleadings are complete and
This is 37 application, 37 appeal.
yes, it's an appeal.
37.
Yes.
My Lord, I'm appearing for the respondent number 1 and 2.
Okay.
I'm being led by Senior Advocate Pradip Sen Deka from Guwahati.
Okay.
So they would like a fixed date, 27-1,
You suggested it will
27-1, 2025.
January 27th.
27th. Monday?
Yes, my Lord.
Okay. Pleadings are complete and the learned counsel have jointly submitted that the matter can be taken up for final disposal. Full stop. Para? List for hearing on 27
January.
1, 2025.
Obliged.
Item numbers 10 to 14.
My
As
Lord,
agreed to, comma, list for hearing. As agreed to, comma, list for hearing. Yes.
On request of my learned friend SK Mehdi,
Yes.
the matter may be adjourned till 20
You are referring to
January.
the judge SK Methi?
Yes, my lord.
I did not make any request here. Yes.
He
The
missed
judge
his
is not your
flight.
learned friend. Okay. What is it? Item number?
Item number 10 to 14. The connected writ appeal has been pending at Guwahati, my lord. That case will be listed on 7 January 2025. Then this matter may also be listed again on 20 January.
There is a connected matter at Guwahati, it's principal bench.
Yes, my lord.
Fixed on?
7/1/2025.
So we'll have this after 7-1? Okay.
Judge, but it's writ appeal is pending.
Writ appeal, okay. Oh.
Writ appeal 265 of 2023.
Heard three so learned counsel for the petitioners as well as Ms. So learned state counsel. Full stop. The learned counsel for the parties have informed this court that a connected WA number
265 of 2023.
265 of 2023 is pending consideration before the principal bench, which is fixed on 10th of January.
7th of January.
7th of January 2025. Para, in view of the aforesaid submission, let these matters be adjourned to be listed in the last week of January. Is it okay?
Judge, but I think they want a fixed date.
Suggested it, we'll fix it.
2020 if possible, my lord.
20th January.
20.
Yes, my lord.
Okay. As jointly requested, place this matter on 21/2025.
I'm obliged.
Obliged.
Item number 15.
My please, Your Worship, I am appearing on behalf of my senior, Mr. Joniel Tauchong, counsel for the petitioner in this matter. And my lord, my senior is unable to attend due to personal difficulties. If the matter may be fixed, may be listed after some time, if possible, my lord.
After some time,
At a later date, whatever is possible, my lord. After vacation.
appeal lies against a discharge order.
Pardon?
Appeal lies against a discharge order.
Yes.
Does it lie?
I don't know, my lord.
Okay, we'll have it after the vacation. You are seeking time. You are seeking time on behalf of your senior.
Yes, my lord.
Okay. A prayer for adjournment has been made on behalf of three so and so. Who is the senior?
Mr. Joniel Tauchong.
Took the names. Learned, got the name? Learned Counsel for the appellant. Para? List immediately after the winter vacation.
Obliged, my
Orders, item number 16.
My lord, same goes to item number 16. Also.
Same.
Yes. The same prayer, my lord.
You are for the respondent here.
Yes, my lord.
Who's for the petitioner? Bail? Okay.
My lord, for the petitioner, but Mr. B.K. Mahajan have tried the link, but there is a technical problem, so.
Okay, when? After the vacation?
Yes, ma'am. Okay, my lord.
Don't be bogged down. If you want something else, we can consider your case. He
My lord,
says, you said okay with a very pensive mood.
Lordship, if it may be passed over and if I may talk to them regarding the
Today it may not be
because they
possible.
have a technical problem, that's why they cannot get in the link.
You have an interim order, or is it for the first time?
Okay, then, my lord.
First time, first time. Listed for the first time.
Yes, my lord.
The regular bail. Is it a regular bail or what?
Yes, my lord.
You are in jail.
Yes, my lord. They are in jail. All of them. 3 of them.
So don't take an adjournment till the vacation. It will not serve your. It will be against your client's interest. We'll have it any day after tomorrow or tomorrow. Try tomorrow.
Tomorrow, my lord.
Tomorrow.
Yes, ma'am.
Okay. On a request made on behalf of the applicants, matter is adjourned to be listed tomorrow.
Yes, my lord.
Item number 17.
My lord, this IA is for implement of the Union of India Secretary, Ministry of Defense and the BRTF authorities in the main writ petition, my lord.
Is it? Why?
Because, my lord, whatever compensation to be paid to the petitioners will subsequently have to be paid by the Union of India, my lord.
The
So-
petition pertains to a claim for compensation, land compensation.
Not actually, but the land of the petitioners was acquired, and there is another writ petition, a bunch of writ petitions pending in that matter. But this specific writ petition is for rehabilitation and resettlement award, my lord. Initially, the
Okay, heard Sri Swensu Learned Counsel for the applicants / writ petitioners, who by means of this application has prayed for implement of the following as respondent numbers
6, 7, and 8, my lord.
6, 7, and 8. You get this from paragraph 2 at page 3, okay? 1, 2, 3. Okay? Following 1, 2, 3, as respondent number, it will be continued. Give the entire address. Page 3, paragraph 2, page 3 and 4. It is submitted that for a complete adjudication of this matter, the presence of the aforesaid respondents would be necessary, as the amount, if granted, would have to be paid by the said authorities. Full stop. Also heard Ms. So-and-so Learned State Council as well as Ms. So-and-so Learned Council for the Learned CGC, para. After hearing, this court is of the opinion that in the interest of justice, presence of the proposed respondents would be necessary. Full stop. Accordingly, the instant application is allowed by implementing the aforesaid parties as respondent numbers, aforesaid parties as respondent numbers 6,
7, and 8.
6, 7, and 8. I stands disposed of. Before that, write one more line. The Learned Counsel for the petition applicants is accordingly directed to file amended cost cycle and thereafter serve the consolidated writ petition upon Ms. So-and-so Learned CGC. Please, the writ petition, para I stand disposed of. You write in the writ petition then. Why an order passed today that is so and so, that is today's date. Implement of respond numbers 6, implement of the following parties have been allowed as respond numbers 6, 7, and 8. Then write down the parties. Okay, 1, 2, 3. Para. It is already directed that amended cost title be filed by the learned counsel. Full stop. Miss so-and-so learned CCC accepts notice on, no, para, don't write it. Let notice be issued to the newly implemented respondent number 6, 7, and 8. Para, Miss so-and-so learned CCC accepts notice on behalf of the newly implemented respondents 6, 7, and 8, who prays for and is granted 4 weeks' time to obtain instructions / file affidavit in opposition.
Obliged.
Item number 18.
Yes, Lordship, this is an application for continuation of 353 days delay in filing the connected appeal.
First time.
Yeah, Lordship, at this stage, let notice be issued upon the respondent.
Heard Miss
Eight members
learned
of
counsel,
State Council.
learned state council, who by means of this application filed under section 5 of the Limitation Act has paid for condonation of delay of
353 days.
353 days in preferring the connected appeal. Full stop para. Let notice be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the respondent numbers 1,
1 to 4.
1, TO2, 4 by registered post with AD. Steps within 2 days.
Deeply
List
obliged.
after 6 weeks along with service report.
Item number 19.
My lord.
IA4?
Lordship, is similar matter. Lordship, we have filed an IA here. We have not been able to procure the certified copy of the judgment, Lordship. Lordship, we have applied the judgment since 26th of September 2024. However, the concerned dealing assistant, they have not been able to trace out the record, Lordship. The original
But you
record.
have an uncertified copy.
We have uncertified. We have given a CTC copy, Lordship.
Okay.
Page
The
46 annex
matter
to
is
one.
yet to be, notice is yet to be issued in the main response, in the main petition.
Lordship, it is the same matter on 5 other matters on which the Lordship has already issued notice and granted a stay.
Okay.
Only this has been listed separate because of the IA, Lordship. So we may be allowed to proceed on the matter with the CTC copy we have submitted of the judgment.
Okay.
And Lordship, as and when we obtain the certified copy, we'll file it on the strength of an affidavit.
Okay.
And here also, Lordship, it is the same matter. If I can draw your Lordship's attention to page 64.
Okay, we'll pass orders. Okay. The main orders, madam. Main orders is already been passed in the first. That will be the same. In the IA, we write. Third, Sri N. Khare, learned counsel for the applicant who, by means of this application, has paid for dispensing with filing of the certified copy of the impugned order at present. Full stop. It is submitted that in spite of efforts made and the certified copy being applied for, the same has not been made available. Full stop. At the same time, the learned counsel has submitted that due to further developments in the office of the collector, grave prejudice is being caused to the applicant. Full stop. Para. After hearing, the IA stands allowed, and the petition and the connected petition would be considered without the certified copy for the present. Full stop. It is, however, directed that as and on when the certified copy is received, the same be filed before this court immediately. Full stop. In the main writ petition, the same order. Okay.
Lordship, there is an execution going on.
Well,
That
we'll
may be-
same order, execution.
Highly obliged, Lordship. Thank you.
Hearing list, item number 3.
You contact Vinay, for the other matter. Vinay has typed the other matter, item number 3456. Item number okay.
But please, Ajib.
Who's there for the respondents?
Ajib,
Christmas mood.
The petitioners aggrieved by his impugned order, which is at page 22 of the writ petition, whereby he was relieved of his duties.
Who appears for the other side? Are they aware of the matter? Definitely, I think.
Yeah, they are aware, yes.
Any news? No news.
Well, he's on legs in court number 2, yes.
Okay, luck is with you. We'll have it after the vacation then. Though Sri so-and-so learned counsel for the petitioner is present, there is no representation on behalf of the respondents. Full stop. Para. In view of the aforesaid position, matter is adjourned to be listed immediately in the hearing list to be prepared after the winter vacation.
I'm okay.
Item number 4.
Fixed for tomorrow then.
9:12. 9:12. 9:12 is today. Now this side is not there. Is it a serious Christmas mood or what?
Seems why not?
It seems.
This may be taken.
None appears for the appellant on call, whereas we so and so. What is learned counsel for the respondent number 1 is present. Para. In view of the above, same order, matter is adjourned to be listed after the. I is for what?
I is for, my lord, production of additional documents, my lord, as an evidence, my lord. For the
Under? Filed under?
Order 41, Rule 27, my lord.
What is Order 41, Rule 27?
That, for filing, Order 47, Rule 21, my lord, for filing additional evidence, my
Order
lord.
47, Rule 21.
My lord.
Filing, what are the essentials?
Those are the FIRs and...
What are the essential conditions?
Discovery of new facts, my lord. These were not within the knowledge of the appellant. But the fact insurance policy which they were talking about, my lord, that was already in the knowledge of the...
What was the provision of law?
That was Order 47, Rule 21, man.
Order?
47, Rule 21, man. 41, Rule 27.
I'm mixed up. Not 47-21, 41-27.
41, Rule 27. I'm sorry. It's just confused.
Okay. Come prepared next time.
Mal.
Item number 11.
Here for the respondent 1, Mr. Malhotra. Item number 11.
Yes, Josh.
Other side not there.
Not there.
All walkover is going on since the morning.
And everyone is in a holiday mood, Josh. That is the problem.
Okay. You want the court to also come to a holiday mood?
In fact, Josh, today we have a meeting. We have an advanced Christmas. charity program, the Bar Association.
Is it?
And it is fixed for Friday, coming Friday.
Okay.
So we're going to have a meeting today, finalize the details. So, I mean, everyone's in that mood now.
Okay, same order. Huh? None appears for the appellant on call, whereas Sri Swansea Learned Counsel is present for response number 1. Para, huh? Same order after the vacation hearing. Only 3, 4. How many are there? 19. One.
Item 12.
In this case, my lord, I was belatedly informed by the senior counsel for the respondent that he is being engaged in the principalship through VC. So if this may be taken up as agreed by both parties after vacation.
VC is not required to go there.
He's being engaged.